there, and then camera will be.
That will
Actually, the camera works this way only. When you click this button, the camera will focus on you.
Okay,
And
because
it-
this is online.
online.
Okay.
जब कैमरा चलेगा तो उसके ऊपर आ जाएगा, जो भी अंदर माइक प्रेस करेगा
Okay,
तो
this is
वहाँ पे
online also. So
Good afternoon, one and all. We have gathered for the plenary session where we have officers from the Insolvency and Bankruptcy Board of India who will be sharing their insights and their practical experience so far as the implementation of this important enactment, that is Insolvency and Bankruptcy Code, is concerned. First, we have with us Ms. Namisha Singh and Ms. Sanchal Raj. Ms. Namisha Singh is a manager at IBBI, Manager Advocacy, and as stated in the morning, she is instrumental in execution of the MOU between the Rajiv Gandhi National University of Law and the Insolvency and Bankruptcy Board of India. So she will be presenting on conundrum and cures, analysis of the interplay between Insolvency and Bankruptcy Code and other laws. Over to you, ma'am. Thank you.
thank you so much for the introduction, sir. So, good noon, everyone. I, along with my co-author, Ms. Achal Raj, will be presenting this paper on conundrum and cures, an analysis of the interplay between the Insolvency and Bankruptcy Code and other existing statutes. So, before delving deep into the nitty-gritties of our research paper, I would, if I can just change the slide. So I would like to mention that the views that we have expressed in this research paper and the presentation as well are our personal views of the authors in our personal capacities, and we have written this paper solely for creating awareness on this particular subject. So, as we all know, that since enactment of Insolvency and Bankruptcy Code 2016, it has been very dynamic. It has been a landmark legislation which was introduced for streamlining the insolvency and bankruptcy framework of in India, and to bring a time-bound resolution mechanism for the distressed businesses in India. Thank you. So yeah, uh, what I was saying was that the Insolvency and Bankruptcy Code has brought out an time-bound resolution mechanism for the distressed businesses in India. So before going forward, I want to give a brief snapshot of the corporate insolvency resolution process under IBC that we have. So I am sure that everybody must be well equipped with the CRP process here, but still I would like to reiterate the whole process for setting a tone. So any corporate debtor having a minimum debt and default of rupees 1 crore is eligible for application and admission of its CRP under the code. And This application for CRP is admitted by the adjudicating authority, which is the NCLT under the code, and it also, with admission of the whole process of the CD, it also appoints an insolvency professional for taking care of the operations and management of the corporate debtor during the corporate insolvency resolution process. And it initiates a moratorium, often called calm period, during which there is no possibility of no suits or legal proceedings can be initiated against that corporate debtor or its properties. So it is section 14 of the IBC. Thereafter, the insolvency professional publishes a public announcement intimating about the CRP of that particular corporate debtor for the larger good of the public. Thereafter, the insolvency professional forms a committee of creditors and appoints a registered valuer to determine the fair value and liquidation value of the corporate debtor. Thereafter, he or she prepares an information memorandum of the company, which includes the audited financial system, financial details, assets and liability details, list of creditors, list of litigations that are ongoing or pending for the company, and the list of guarantees it has provided, all these things, and then it publishes an expression of interest for the purpose of request for resolution plans. Thereafter, the insolvency professional receives resolution plans from prospective resolution applicants ideally within a time frame of 135 days. And after this, all the resolution plans are presented before the committee of creditors so formed by the insolvency professional, and they use their commercial wisdom to decide on and select on the resolution plan. And thereafter, once selected by the COC, it is sent to the adjudicating authority to see the legal aspects and finalize whether the company is to be resolved or liquidated. So the whole process that we see is a process of 180 days, which can be extended by 90 days, thus giving us a timeline of 270 days, which can also be further extended to 60 days. That is, 60 days time period is for the litigation period that happens during the CRP process. So keeping this process in mind, we'll be starting with the research paper that we have tried to carve out. So this is the flow of presentation for a research paper. The introduction, rationale of study, objectives and intent behind writing this research paper, the stages of interplay of IBC with other existing statutes, the existing jurisprudence at different fora, conclusion and the way forward. So while writing this research paper, we had in mind that there are several stages in a corporate insolvency resolution process wherein the intertwining of IBC with other laws sets in. So keeping that in mind, we have tried to understand various facets of insolvency and bankruptcy code and its intertwining with other laws. And the other laws that we have covered here in the research paper are Securitization and Reconstruction of Financial Assets and Enforcement of Security and Trust Act, Real Estate Regulation and Development Act, taxation laws. We have also considered Tea Act, Electricity Act, Prevention of Money Laundering Act, Arbitration Act, and many more. So the rationale of this research paper is that we had observed there are many issues which are leading to litigations during the corporate insolvency resolution process, thereby delaying the whole process. There were issues like there were departments and authorities attaching the properties of the corporate debtor or bank accounts of the corporate debtor during the moratorium period, or there were taxation authorities who were implying 1% TDS for transfer of immovable properties, like that. There were employees' dues and arrears issues. So we have tried to identify the issues, and based on those issues, we have tried to identify the orders of different fora, and we have tried to collate them. So to understand the stance as of today, existing stance on these intertwining of laws. The objective is to understand, as I would like to reiterate that to understand the interplay of the code, we have written this paper and analyzed the existing jurisprudence. We have analyzed orders of different fora, And we have tried to contribute to the ongoing discourse on enhancing India's insolvency and bankruptcy framework. We have also tried to facilitate ease of doing business by writing this paper and promoting economic growth in this section. So, with this, I would hand it over to my co-author, Ms. Aanchal Raj, to take it forward.
Thank you, ma'am. After the elaborate description of the whole CIRP process, we'll now see the stages during which the interplay between other laws and the provisions of the code occurs. Firstly, the very first instance where we can see the interplay is at the stage of admission of an insolvency application. When an insolvency application is filed by any creditor, the court is required to see whether that creditor is even eligible to file the application, and these eligibility requirements arise from the agreements that the creditors enter into with the concerned corporate debtor. Therefore, it becomes imperative to see whether the contractual rights can be enforced and whether it can be harmonized with the provisions of the code. Next stage would be the applicability of moratorium. As soon as the application is admitted by the NCLT, it declares a moratorium on the assets of the CD, whereby the assets cannot be disposed of. This is done for protecting the value of the assets and for maximizing the value of the assets. At this stage, various other laws like state laws interact with the provisions of the code. In the coming slides, we'll see how moratorium has been given a sanctity even when it is interacting with other laws. Next stage is processing of claims. Whenever claims are filed, the RP is required to see whether those claims are valid or not. And a very important aspect is that of claims of employees. So during claim processing also, we can see that the provisions of IBC interacts with various labor laws. Next, if at the stage of approval of resolution plan, in the case of SR Steel, the Supreme Court held that the clean slate principle applies, and this principle states that when an SRA acquires the assets of the CD, which has been rehabilitated, it should not be faced with any sudden claims which have not come beforehand. During approval of resolution plan, sector-specific regulations may also come into play. For example, the company may belong to the telecom sector, or there may be an electricity regulator that their regulations apply, and therefore resolution plans should also consider those provisions, and those provisions should be adhered to. All laws should be adhered to. At the stage of liquidation, the interplay between IBC and property laws becomes evident, because sale of assets occurs during this stage. Now we'll discuss the existing jurisprudence that there is. In the case of Rajendra K. Bhutta versus Maharashtra Housing and Area Development Authority, this case was decided by the Supreme Court. The bench consisted of Justices R.F. Nariman, Ravindra Bhatt, and Ramasubramaniam. In this case, there was a tripartite agreement that was entered into among three parties. Under the tripartite agreement, the CD had a license to enter upon a property and develop the property. This license provided the CD the occupation of the property. So the Supreme Court held that the occupation means physical possession of the property, and therefore Section 14 would apply. The contention was that the Housing Development Authority terminated the license that was granted under the agreement and wanted to repossess the property. So the Supreme Court held that this notice that has been issued for termination will not survive in light of Section 14 of the Insolvency and Bankruptcy Code. In the case of Pioneer Urban Land and Infrastructure Limited and another versus Union of India, this was again decided by the Supreme Court, and the bench consisted of Justices R.F. Nariman, Sanjeev Khanna, and Justice Suryakant. In this case, the Supreme Court was faced with the interplay between RERA Act and the IBC. The court ultimately held that the IBC and RERA operate in different realms, but if there is an inconsistency between the provisions of the two, the code would prevail and RERA would have to take a back step. Next, in the case of Innovative Industries versus ICICI Bank, this was again a Supreme Court judgment pronounced by the bench led by Justice R.F. Nariman and Justice Sanjay Kishan Kaul. In this case, the Maharashtra Relief Undertaking Act consisted of a provision whereby the government issued two notifications because of which the liabilities were temporarily suspended. The liabilities of the CD were temporarily suspended. So the contention of the CD was that the liability or the debt has not become due and payable. The Supreme Court, while interpreting the provisions of IBC and MRUA, held that if MRUA is given, if MRUA is applicable, then the provisions of IBC would take a back step and would not be able to, and the CD will not be able to be rehabilitated. So the Supreme Court held that MRUA being a state act and IBC being a parliamentary act, the IBC would take precedence over the act, and Section 238 of IBC would override Section 4 of the MRUA. Section 4 of the MRUA also imposed a moratorium, but Section 238 of IBC, read with Section 14, would precede that and would be applicable in this case. In the next case, the provisions of T Act and IBC interacted. In this case, it was provided under the T Act that in case any winding up proceedings were to be conducted or an official liquidator was to be appointed, the consent of central government was mandatory to initiate such proceedings. But under the IBC, no such consent is mandatory. Therefore, in this case, the court held that the consent of central government will not be required, as the provisions of IBC will override the provisions of the T Act. In the case of Principal Commissioner of Income Tax versus Morne Ispat, the Supreme Court simply held that because of the existence of Section 238 of the Insolvency and Bankruptcy Code, which is a non-obstant clause, it is evident that it will override all other provisions which are in inconsistency with the provisions of the code, read with Section 238. In the case of Om Prakash Agarwal, liquidator of S. Kumar's Nationwide Limited versus Chief Commissioner of Income Tax, in this case, the liquidator conducted an auction and a property of the CD was sold. On this sale, there was a 1% TDS that was being levied by the successful resolution applicant and the income tax authority. It was contended by the liquidator that such imposition of TDS is against the waterfall mechanism that is required under Section 53 of the code, as it gives precedence to statutory dues over other secured and unsecured creditors. The court, while interpreting the sections, held that Section 194IA of the Income Tax Act, which provides for levy of TDS, will not be applicable in this case because under the aegis of the code and the objective of the code, the government dues cannot be given a priority over other dues as per the waterfall mechanism given in Section 53 of the code. In the case of Mr. Ashutosh Agarwal versus Joint Commissioner of State Tax, certain notices of attachment of bank accounts of a CD was issued by the State Tax Authority, and it was held by the court that such notices will not be issued as soon as the admission of application occurs, the moratorium is imposed, and therefore attachment orders cannot be passed. Next, we see the interaction of provisions of Insolvency and Bankruptcy Code with the Arbitration Act. In the case of K. Kishan versus Vijay Nirman Company Limited, there was an arbitration award that had been passed against the CD, and the operational debtor had challenged the award under Section 34 of the Arbitration Act. And the question before the court was whether, when the challenge is pending, whether a Section 9 application can be admitted or not. So the court held that a Section 9 application can still be admitted, even if there is a dispute which is pending adjudication. In the case of Reliance Commercial Finance Limited versus Wade Cellulose Limited, the Section 7 application was under consideration. In this case also, there was an arbitration happening simultaneously, but the court held that there is no provision of a dispute under Section 7 application. Therefore, initiation of CIRP is not hindered by a pending arbitration proceeding. Next, we see the interaction of Companies Act and IBC. In the case of Jaipur Metals and Electrical Employees Organization versus Jaipur Metals and Electrical Limited, there were certain winding up proceedings that were pending before the board, before the previous board, that is before, under the SICA Act. The NCLT thereafter admitted an insolvency application, but the High Court set aside this admission order, stating that winding up proceedings will be carried out under the Companies Act. But the court finally held that the NCLT has been empowered to entertain the applications, and therefore the admission application is valid. Admission order is valid. And Section 238 will override the provisions of Companies Act. Next, in the case of Jagmohan Bajaj versus Shivam Fragrances Private Limited, the tribunal again held that there was an internal dispute between the directors of the company, and the directors filed an appeal stating that an insolvency application cannot be admitted while there is an internal dispute and there is a pending application of oppression and mismanagement. So in this case, the court held that because of Section 238, the provisions of IBC will override the provisions of Companies Act, and therefore a pendency of Section 241 and 242 application before the NCLT regarding oppression and mismanagement will not hinder the admission of insolvency application under the code. Handing over to Ms. Amisha, ma'am, for the later part of the presentation.
Thank you, Achal. So we'll be proceeding forward with the interplay of Insolvency and Bankruptcy Code with Prevention of Money Laundering Act. Under PMLA, we have seen that there is a concept of proceeds of crime based on which we have listed the orders. So in case of proceeds of crime, if a property is believed to be a proceeds of crime, then the Enforcement Directorate under the PMLA can attach the property by a provisional attachment order. And in case property is attached, it can also be confiscated, which means that the control and management of the property is vested with the central government, free of all encumbrances. So keeping that in mind, we have listed the orders. So the first order is Varsana Ispat Limited versus Deputy Director, Enforcement Directorate. In this matter, the appellate tribunal has held that PMLA relates to different fields of penal action of proceeds of crime, and it has to be invoked simultaneously with the Insolvency and Bankruptcy Code and having no overriding effect of one act over the other. Similarly, in the matter of Rotomac Global Private Limited versus Deputy Director Enforcement Directorate, the appellate tribunal had placed reliance on the matter of Varsana Ispat Limited, and it has held that moratorium under Section 14 of the Code is not applicable to attachment proceedings under PMLA against properties acquired through proceeds of crime. The appellate tribunal proceeded in this case on the basis that there is no inconsistency between the code and the PMLA, and both have to be cohesive and equally they have to be in place. So after that, there was a judgment of High Court of Delhi in the matter of Rajiv Chakravarti versus Enforcement Directorate, wherein the same issue was dealt with, and the High Court had held that Enforcement Directorate is empowered to attach the assets that are believed to be proceeds of crime only if Section 32A of the code is not triggered. So we have already discussed in the inaugural session about the clean slate principle, that the successful resolution applicant or the new management, as we say it, they should start afresh, and they should be immune to the attachment and by the ED and the CBI or SEBI. for that matter. So, however, the legal position by the Supreme Court is still sub judice in the matter of Ashok Sarvagi. So, we just have to see how conclusively it is determined by the Supreme Court. Moving forward, we have interplay of Insolvency and Bankruptcy Code with Electricity Act. So here we have placed the Pashchimanchal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited matter. So in this matter, PVVNL has appealed for release of property during the liquidation under the code for its sale and distribution of the proceeds. So here in the Electricity Act, we could see that there were two non-obstantive clauses, 173 and 174. And PVVNL had appealed that this 173 and 174 will override the section 238 of the code. However, it was held by the Apex Court that the section 238 of the code overrides the provisions of the non-obstantive clauses of the Electricity Act. This, as we were talking in the inaugural session about the rainbow papers, so which is also under review. So Pashchimanchal has also clarified on the rainbow papers judgment. So moving forward to IBC and the interplay with SURFACY. So under Securitization, Reconstruction of Financial Assets and Enforcement Security Interest Act, there is a provision for the banks and financial institutions to auction the properties of the companies under distress to recover their loans. So, with that matter, we have listed out this Indian Overseas Bank versus RCM Infrastructure and other. In this, the same issue was discussed whether any financial institution can realize security under this act SURFACY during the moratorium, during the ongoing period of the CRP. So the Apex Court had held that Section 14(1)(c) of the IBC has an overriding effect over any other law. Consequently, any action to foreclose, recover, or enforce any security interest created by the corporate debtor, including its actions under SURFACY, is prohibited during the CRP. These are all the acts that we have covered for interplay of IBC. In the end, we have concluded that it is a complex process. In all, we have tried to bring out the synergies, dependencies, and any conflicts that arise. So, I understand that I and my co-author Anchal Raj have tried to conclude that we require a seamless integration of the code with these laws so that IBC can be better implemented. Further, any dissonance between the realms may lead to prolonged legal battles, which we had already observed earlier before starting with this topic for the research. And then harmonizing these legal frameworks becomes imperative to create a favorable environment for the businesses and other stakeholders. What we are suggesting that over past 7 years, we have seen that the legal aspect around IBC has evolved as it is very dynamic. The challenges we have tried to combat through various different judgments of for us. We have tried to combat the challenges, and now it is a time that there's a pressing need to educate the other authorities about the in IBC across legislations. So, it recognizing its roles in India's economic growth, and there will be a call to adapt a legal framework to evolve business landscape. This research is basically based on some of the judgments of various different laws that we have covered. However, we have tried to step in so that this can serve as a guiding factor for other stakeholders to proceed forward before litigating during the corporate insolvency resolution process. So that's all from our presentation. Thank you.
Thank you so much, Ms. Namisha and Ms. Anchal Raj, for touching upon various laws which we and Mr. Anil Katia, we were discussing in the morning that insolvency and bankruptcy code, it touches upon various aspects. And there are so many laws with which it has an interface, be it law of contract, be it property law, be it taxation law, direct taxes, indirect taxes. In the morning, we were talking about mediation also. Fine. So, Electricity Act, Real Estate Regulation Act. So, probably you have set the tone for the panel discussion, which is scheduled to be held tomorrow, where we will be discussing through a galaxy of experts, where Mr. Anil Katia will also be part of that. Uh, how the IBC has its interface with various laws, and how, as we understand, that though it's more than 6 years now, the law is still evolving to various adaptations, to amendments by the legislature, to issuance of regulations by the regulator, and to higher judiciary decisions also. And probably we are still in the infancy stage, and in some time, in a decade or so, it will be a more mature law. Any questions, any comments, any queries, any observations which the presenters have got before we move on to the next presentation? Thank you, Mr. Katia, for highlighting that the enforcement directorate's role in IBC, of course, all other matters, taxation matters also, that is increasing, and of course, that is required to be addressed. Any other comments, observations, queries? Yes. There's another point just to add to it. As we said that the law is still at its infancy, still to settle down. The interplay is being, I mean, every other day you find some new development, new nuance of the law coming into limelight. And probably it will take time for the judiciary to settle down the interpretation. And as we discussed in the morning, the legislature has come up with a host of amendments. And I think even IBBI has resorted to more than 80 odd amendments to the regulations which they have made. They are trying to adapt the law to the growing demands. As I said, probably it would take more time to settle down. Thank you, Mr. Katia. We move on to the next presentation by Ms. Anchita Sood and Ms. Archana Sharma. Ms. Archana Sharma is Manager CIRP at Insolvency and Bankruptcy Board of India. Her paper is titled Beyond Recovery, Harnessing Value Through Asset Reconstruction Companies. I'm sorry I didn't take that question because we had reserved 1 hour, and otherwise we will be delaying our schedule by more than 1.5 hours today. So probably we will have the lunchtime with us where we can take more questions. That is 45 minutes. So I'm sorry not to have taken the question. Over to Ms. Archana.
So good afternoon, everyone present here and joining us online. This is me, Anchita Sood, and my co-author Archana Sharma. We are here to present our paper titled Beyond Recovery, Harnessing Value Through Asset Reconstruction Companies. Before we begin with the presentation, I would like to inform everyone that the views expressed in this research paper are those of the authors in their personal capacity, and this research paper is presented for the sole purpose of creating awareness on the subject and must not be used as a guide for taking or recommending any action or decisions. The researchers who want to use this can seek professional advice if they intend to use this for future. So moving forward to the research paper, in this research we have tried to eliminate the untapped potential of asset reconstruction companies, which when effectively used can be harnessed and can usher a new era of financial stability and growth. So starting with, the efficient resolution of financial stress holds paramount significance, not only for the stability of the financial sector, but also for the overall economic well-being. And the resolution of financial distress extends far beyond mere recovery. It is about the profound transformation of non-performing assets into valuable resources. The two most important developments, that is SARFACI and IBC, have been instrumental in not only rescuing the distressed assets but also in harnessing their hidden potential to create a substantial value. SARFACI Act basically empowered banks and financial institutions to recover the secured loans efficiently and going beyond the traditional court interventions. And it also cemented a way for the establishment of ARCs as a potential instrument for resolving the non-performing assets while simultaneously extracting and enhancing the asset value. So, if we go into the inception of ARCs, it can be traced back to the significant financial sector reform inspired by the recommendations of Committee on Banking Sector Reforms, which is Narasimha Committee 2, which was set up by Mr. P. Chidambaram, the Finance Minister of India in the year 1997, as an effort to address the issue of non-performing assets in the banking sector. I'll be dealing with the concept of NPAs thoroughly in the upcoming slides. So basically, to tackle with the problem of NPAs, the concept of ARCs were introduced to help bank in offloading their distressed assets and focus on their core lending activities. Moving forward, asset and their reconstruction, all of us know that India's economic landscape is very complex, and it contains assets in various forms ranging from real estate to infrastructure projects to corporate loans and financial instruments. And in this dynamic environment, the concept of asset reconstruction has gained prominence as a critical process for ensuring financial stability and reviving the distressed assets. One of the fundamental pillars of asset reconstruction in India is SARFACI, which offers a robust mechanism for asset recovery, allowing the lenders to take the possession of the collateral without the need of court intervention. And this enables the swift recovery of outstanding dues. However, the significance of SARFACI Act goes beyond mere recovery, and it serves as a catalyst for the asset reconstruction, especially in the context of non-performing assets. Now, let's understand the concept of NPAs. So, it is well said that a banking system with adequate capital giving capacity helps in meeting with the demand capacity of the future. So, the process of banks extending loans to individuals, business, and various economic sectors is a fundamental driver of economic expansion. And these loans are provided with the expectation that they will be repaid within the stipulated time along with the accrued interest. This cycle of lending and repayment sustains the financial ecosystem and ensures the availability of the funds for new projects. However, when the borrower fails or borrower encounters any financial difficulties and they are unable to meet the repayment commitments, it results in what we commonly call as loan default. And in India, this default is majorly known as the non-performing assets. And NPA creation is a major issue, and as they break the credit capacity of the banks. When NPAs accumulate within the banking sector, they have far-reaching implications, and it not only affects the financial health and stability of the banks, but also ripples the economic landscape. Therefore, addressing the NPA issue is very important for the sustaining of economic progress. Now, to deal with these issues over years, successive governments have taken various steps, and they have collaborated with the industry leaders to develop various approaches to improve the non-performing asset situation in the country. Several mechanisms have been put into place to tackle this challenge. First one was DRT, that is the Debt Recovery Tribunal. And the need for such an entity arose from the recommendations which were put forth by Narasimha Committee 1, as all of us know that, which is known as the Committee on Financial System, which was commissioned to conduct an extensive examination for nation's banking infrastructure and propose comprehensive reforms to revitalize it. These tribunals were set up to provide a faster and more specialized legal resources to recourse to bank and financial institutions to recover their dues from the defaulting borrowers. As a parliamentary creation, DRTs were entrusted with the responsibility to deal with loan recovery cases, but not limited to claims amounting to rupees 10 lakhs or less. However, they were also allowed, or they were authorized to establish lok adalats, which in turn could deal with the cases amounting to, which could go up to 20 lakh of rupees. So initially in the year 2003 to 2004, they showed commendable results, and the recovering rate, if I can quote, was 79.1% in that year of the total outstanding amounts. However, as the time progressed, the efficiency of DRTs as an asset resolution mechanism underwent a stark decline, and subsequently through the years it started declining, which then led to the establishment of Sarfasi Act. That was established in the year 2002, and with this, the introduction of this act, India took a leap in addressing the NPA situation that was existing at that time. And this act basically granted banks and financial institutions the authority to recover the secured loans by enforcing security interest and auctioning the borrower's properties without requiring court's intervention. So Sarfasi empowered banks to take more decisive actions to manage and recover the NPAs efficiently. Along with the Sarfasi Act, government also cemented a way for the establishment of ARCs. Now, ARCs were basically created as a specialized entities that were tasked with the acquisition of and management reconstruction of the distressed assets. They generally offer a structured approach to reviving the maximizing the value of the distressed assets, focusing on comprehensive asset reconstruction rather than merely recovering dues. Another act that was recently, as we still call it recently, that was introduced in the year 2016 was the Insolvency and Bankruptcy Code of India. And the IBC represents a comprehensive framework for addressing the financial distress across a spectrum of entities, including the corporations, partnership firms, your individuals. So IBC's goes beyond the traditional recovery method and emphasizes for the optimization of asset value. It aims at the rehabilitation and revival of financially distressed entities under the judicial supervision. Moving forward, let's have a brief look at the functioning of ARCs. So ARC, as I just told, act as a specialized financial institution that play a crucial role in the resolving of NPAs. The first step that is followed by as a function or in the throughout the ARC is the identification of the distressed assets, wherein the banks or financial institutions identify the loans or assets that have turned non-performing, and meaning that the borrower is unable to pay that as agreed. The next step is the transfer of distressed assets, wherein bank transfer their distressed assets to ARC. Third, if we may call it third, the ARCs then negotiate with the banks or financial institutions to acquire these distressed assets at a discounted price. Generally, the price is lower than the actual original value of the assets, and bank transfer these assets to ARC to clean up their balance sheets and focus on their core banking activities. Next step is the asset valuation and due diligence, wherein ARCs conduct thorough due diligence of the acquired assets, and this helps them to assess the actual value of the assets and understand the underlying business that and to formulate a proper resolution strategy for each kind of asset that they have acquired. The next step is resolution planning, wherein ARCs develop strategies to resolve the distressed assets. This can involve various approaches like debt reconstruction, asset sale, or maybe business turnaround, or if legal actions if it is required. So all these approaches are followed to formulate a resolution plan for each kind of asset that the ARC have acquired. Then they negotiate with the borrowers of the distressed assets to find a solution for repayment. This might involve restructuring the debt, offering concession, or finding alternative ways to recover these dues. Further to this, debt restructuring and asset management is also done by ARCs, wherein ARC manage and monitor the acquired assets. They might actively engage in managing the business or the to enhance the value before selling or actually resolving them. The last one is the asset sale, wherein ARC aim to recover the funds by selling the distressed assets. This can involve selling assets individually or in portfolios to investors or strategic buyers. Then recovery of funds is another step wherein the proceeds of the asset sale, debt recoveries, or the strategy resolution strategies are used to recover the outstanding dues of the distressed assets. Then once all of these things are done, then the profit sharing is done, and generally while distributing the value, the what ARCs follow a waterfall mechanism wherein the resolution and legal costs are paid first in priority, and followed by the NAV, and then followed by the security receipts that has been issued to the stakeholders. My co-author Archana will be taking forward with the presentation. Over to you, ma'am.
Thank you, Anchita, for this comprehensive overview. So now we'll move on to the role of ARCs, and if we see the cohesiveness with the Insolvency and Bankruptcy Code. So if we see that ARC is the legislation regarding ARC, that is the Efficacy Act, that is a very focused legislation, and it was meant for the secured loans which were extended by the banks. And if we talk about the Insolvency and Bankruptcy Code, it is basically a reorganization of all the laws which are concerned with restructuring, and it has main objectives which include the maximization of value of assets of CD, then promoting entrepreneurship, enhancing the availability of credit, and balancing the interest of all the stakeholders. So, if we see the role of asset reconstruction companies in the insolvency and bankruptcy landscape, so they primarily they perform two kind of roles. One is as the initiator of the process or as a member of the COC, and another one as the resolution applicant. So as a initiator of the process, as a financial creditor, they can initiate the application against the corporate debtor whenever there is default. And in case this corporate insolvency resolution process is initiated by any other, be it a financial creditor or be it operational creditor, so in that case, it can act as a member of the committee of creditors. So essentially, committee of creditors, it is the main body which we can say it supervises the entire conduct of the process, which is carried out by the insolvency professional, and it is a main collective decision making body from which even the RP has to take approval for the major actions which are to be taken. And ultimately, it is the commercial wisdom of the COC that prevails. So, in a way, we can say that ARC, as a member of COC as well as the initiator of the process, they actively engage in the decision-making process related to the distressed company's future, and they essentially decide whether the company is to be, how the company is to be revived, how the resolution plan are to be evaluated and finalized, and how to decide for liquidation of a particular company. Now, if we talk about the another role of ARCs, which is the role of the resolution applicant, so as we discussed and heard from one of our guest of honors regarding the need for having and developing the ARCs as a resolution applicant. So, if we see the section 29A, it imposes certain kind of restrictions wherein certain persons, they cannot be allowed to act as the resolution applicant. However, if we talk about the financial entities, which include the ARC, so there are certain kind of dispensations, and the section 29A restriction is not applicable. So if we look back at the history, so in the matter of Aircel Limited, so one of the asset reconstruction committee submitted the resolution plan. It got approved by the committee of creditors, and later on, as per the Efficacy Act, it applied for approval of the Reserve Bank of India. However, Reserve Bank of India, it proceeded with issuance of a show cause notice stating that it is beyond what is provided about the mandate of the ARCs in the Efficacy Act, and accordingly the matter went up till the level of Honorable High Court of Delhi. So the Honorable High Court of Delhi has held that there is a need for reconciliation between the provision of both the legislation, the Efficacy Act and the IBC. So accordingly, the RBI came up with a circular in October 22, wherein it allowed the ARCs to act as the resolution applicant. However, there are certain kind of riders which were imposed. So one of the condition was that the ARCs, they should have a minimum net owned funds of 1,000 crores to be eligible to act as a resolution applicant. They need to have a board approved policy with the internal limit for the sectoral exposures, and they need to have an internal committee which will consist of majorly the independent directors, and they will decide the participation on a case to case basis. And another important restriction which was imposed, that the ARCs, they are supposed to dilute their control in the corporate debtor once they acquire the debtor after 5 years from the date of approval of the resolution plan. And in case there is a non-compliance in dilution of this control, the ARCs will not be allowed to submit any fresh resolution plan, or either act as a resolution applicant or act as a co-resolution applicant. Further, to enhance the disclosure requirements, the ARCs were mandated to disclose the implementation of the resolution plans which are being approved by the adjudicating authority in their financial statements. Now, after a notification of this circular, although to some extent it relaxed the provisions and allowed the ARCs to act as resolution applicant. However, if we see in the implementation part and the active engagement of ARCs in the insolvency landscape, there are still certain kind of hurdles, or there are still kind of regulatory framework which can be relaxed to allow the ARCs to further penetrate in the insolvency ecosystem. So first is the requirement of having the capital infusion. So earlier it was rupees 100 crores, but now with the circular, the capital infusion amount has been increased threefold. So it is 300 crores as of now. But if we talk about the small corporate debtors, say we have the MSMEs. So for MSME, it wouldn't be possible for a big ARCs to chase the small MSME companies for acquisition or for reconstruction. So in that way, it might discourage the big ARCs to acquire these small MSME companies, and in that way, it kind of hinders the insolvency resolution of the MSME companies. And as Anchita had mentioned in the earlier slides, the overall effectiveness of ARCs has shown a decline. So in the initial years of enactment of the code, the recoveries were as high as 70 plus percentage. However, this has now plummeted to around 20-25% now. Now, if we talk about the the role of specific role of ARC, so they need to focus on their investment on the expertise which they are possessing. So, because ARCs are considered to be possessing sector-specific expertise and industry-specific experience, so they should focus their investment based on their experience and expertise in a particular class or particular industry. And if we look at the data which is available in the public domain about the participation of ARC, so in the insolvency framework, it has been very limited. As resolution applicant, the ARCs, they have shown very limited. The number is in single digits if we see the number of cases wherein the ARCs, they have acted as the resolution applicants. So this is one area where the ARCs need to come up, and they need to further penetrate in the insolvency ecosystem. Now, if we talk about the restrictions which have been imposed by the circular, so another condition is of having this net owned fund requirement of 1,000 crores. So definitely for the low value cases, this higher limit, it gets prohibited for these companies, because the potential benefits are not much. If you are acquiring a small company, the potential benefits are not much. So there is no point for a big company to acquire a small corporate debtor. And the requirement of change of diluting the control after 5 years or within the period of 5 years. So this results in primary two kind of issues. One is that it hinders the ability of the ARCs to implement the plans from a long term with a long term vision, because ultimately they have to lose their control after a period of 5 years. And secondly, it encourages them to buy at a low value and then again selling it at a higher price. So the price discovery is not at the optimum level because of this particular requirement. And this price discovery issue, it has also been highlighted in the matter of Honorable NCLAT, Suparna Dhavanan versus Bharati Defence and Infrastructure Limited, wherein it was said that the purpose of insolvency resolution is not to downsize the operations of CD, but the purpose is to revive. So the resolution applicant should strive for the insolvency resolution and not just for the value addition, and with the intention to selling it off in a shorter period of time. So with these issues, if we see the role of ARCs as resolution applicants, so they serve as a driving force in the resolution process as an initiator, as a member of COC, and they facilitate swift decision making because they offer a unified, streamlined approach and sectoral specific experience. And they do have greater flexibility if we compare to the international counterparts because globally the ARCs they are government regulated entities, but if we see in the Indian scenario they are the public private entities, although they are governed by the Reserve Bank of India provision, but still they have greater flexibility as compared to the global counterparts. And if we see the need for transition from their traditional role of acting as a recovery agents to now rehabilitating and restructuring the entire corporate debtor, so I think this is something which does provide a competitive edge to the ARCs to function in the entire restructuring landscape, not only limited to the IBC. So the further points of consideration are that the both the acts they should work cohesively, and they should maintain a balance between the need for transparency, integrity, and fairness in the process, as well as preventing the potential abuse and the conflict of interest. On one hand, we should provide flexible approach. However, with the flexible approach, there should be some kind of stringent measures, and there should be some measures to regulate the ARCs. So, in the author's view, in our view, there should be a nuanced approach which acknowledges the significance of the regulatory controls, which allows some discretion to the ARCs, as well as it provides the leeway for the regulator, for the regulatory institutions to intervene wherever required. And in certain situations, a flexible and a lenient approach it can also be considered. So, if we are to conclude, if we talk about the ARC, present ARC framework and the conditions which have been brought in by the RBI and the recent committee report in 2021, so there is a need to enhance the regulatory support and flexibility to the ARC to, in order to streamline their operations and in order to empower them to make more strategic acquisitions. However, simultaneously there is a need to provide flexibility and a need to focus, have a lenient approach. And for this, maybe further legislative amendments or maybe through a circular that could be brought out by the Reserve Bank of India. So ultimately, the objective should not only be limited to recovery of a particular asset or recovering a particular amount against a specific loan. So the objective is should be effective and efficient insolvency of the entire corporate debtor, not limited to any specific asset of one particular creditor. So that's about it. Thank you.
Thank you, Ms. Archana Sharma and Ms. Anchita Sood. Since the next presentation is also on asset recovery companies, so we'll take questions after the next presentation, if that suits. So next presentation is by Mr. Asit Behra and co-authored by Mr. Vinay Pandey, both being managers at Insolvency and Bankruptcy Board of India. The presentation title is New Era for Asset Reconstruction Companies in Insolvency, Predicting Challenges and Opportunities Ahead. Over to you, sir. Yes.
6 ARCs put into the model where they can act as a resolution applicant. This clearly undermines the pool of resolution applicants, ARCs as resolution applicants, which is being discussed on introductory thing also. That people emphasize that ARCs can be resolution applicants, which I completely disagree. And tempted to respond. First of all, we must all understand that the Reserve Bank of India is a very, very creditable institution, an institution of repute, an institution of standing globally. What is that the Reserve Bank of India, in its wisdom, rejected the plan of UPA when they acted as a resolution applicant in the matter of law. You cannot just write off the view of the regulator. A regulator whose existence is older than any one of us. So there has to be some reason. First we need to unravel what is holding RBI, make them as resolution. What is that reason? Because we are asking there is some resolution for having whether there is sufficient ring fencing around it, whether there is normally the ARCs act as a resolution applicant, but they will have a trust around it and you will ring fence it so that what happens if the CRP goes down or they're not able to implement the plan, the ARC does not go down in the process because there's essentially public money involved. But in the interest of protecting ARCs, what they've essentially done is they've forgotten the larger intent of the whole ecosystem, where the bank's health is much more important and why the ARCs were there in the first place. The limitations, everybody agreed that there had to be some limitations in place, but the limitations are very severe, and that's what we're trying to point it out. So when you have net own fund of 1,000 crores and there are only about 5 ARCs that can participate in the process, I think it's being too conservative. This is an economic law. We have to agree that this is an economic law. You have to understand that ARCs have become smarter over the years. Their role in turnaround of companies can't be downplayed. And with the passage of time, India will have specialized ARCs which will try to focus on specific sectors and they'll have their expertise. They'll bring in players from outside. So I think that aspect has been missed out. Yes. So I think maybe it needs to be looked again and revisited again. So that maybe the RBI can do that. Maybe is our limited point here. There are price mismatches between ARCs and banks, which is a big problem right now, that what the bank expects and what is the ARC's valuation. And there is a lot of negotiation challenges and potential transaction delays that happens during a CRP also. Apart from that, there are various legal and operational challenges that are continuing that the ARCs face on a normal basis that is there. I think the symbiotic relationship of, so I would talk about, so there are 3 slides. I would basically talk about what could be the way forward for ARCs and what are our expectations as ARCs in the IBC ecosystem. The symbiotic relationship under the IBC was already talked about. But there are some aspects here also that needs to be looked at. The one key area where CRPs have been suffering is that we again going back to the period of elongated resolution time. ARCs can help us put us back into that 270-day regime where they identify a good asset, take it over, turn it around in their own time, and the CRP timeline is matched. That asset is now gone into the market and they do their own turnaround and then they take it and give more value into the market. There are some process streamlining that is still needs to be there. We overall in the IBC ecosystem for valuation of assets, I think there needs to be that much more needs to be done in that area. And there's a price. There's a trust deficit right now in the market as to what the real value is between the public, between the different players in the market, between the courts and tribunals. I think that needs to be addressed too. What
what this will do is that the ARCs will be able to take on these assets in much more earlier and act as resolution applicants. So the another point that I was going for is their role in interim finance. Interim finance is where so basically then IP is allowed to take over interim finance to run the CD as a going concern and to conduct the CRP. Now, right now, interim finance market, when you look at it, the rate for interim finance is very high. It's about 15 to 16% interest rate that is going on. Currently, RBI does not permit ARCs to give interim finance where they do not have exposure in that particular loan in the corporate debtor. I think this can be changed because there are sufficiently large ARCs, and in turn what will happen is the ARCs will make money, and there will be more players in the interim finance market. This is something that RBI can look into. The COVID pandemic affected a lot of businesses, so in a post-pandemic world, ARCs know which are the businesses which are affected by the COVID pandemic and which can be turned around in a couple of years, and they can generate more value, and the value may be less in a recent post-COVID situation, but it will unlock more value in the coming years. Apart from that, technological integration cannot be downplayed. It will enhance the accuracy in asset valuation and due diligence. Also, record trackings and everything. You can use blockchain for record trackings and the other dealings. They can use machine learning and adopt AI to see the distressed asset market as to which are so how an ARC normally operates is they take over the distressed assets. They can use these computation machine learning techniques to see which assets, so they can pick on the asset very early in the market to take over the asset. Right now, ARCs, as we have seen traditionally, different ARCs are not diversified. So even the large ARCs, they invest in particular sectors only. We need to have more diversification so that the risk pool is staggered across different sectors, and the health of the ARCs is also maintained. So they can reduce this risk through portfolio diversification. Another thing is that India has become we're trying to portray ourselves as an investment place and investment behemoth. So these ARCs can forge partnership with global entities, private equity firms for resolution of large assets, pension funds. They can bring in HNI, the other high net worth individuals from outside, and they can leverage their international expertise and capital, convince players from outside India, and then forge partnership with them, and then try to act as resolution applicant. This is for the large.
So what I understand from my experience is that there is no bar on any of these asset reconstruction companies to set up what is called the AIF.
Yeah.
And I don't think when they act as a resolution applicant through the AIF route, they will encounter any of these, entry barriers, which they do as a licensed ARC entity. So that arbitrage is already available to them, is what my point is.
So, but when you look at the AIF route also, even currently when you look at it at the NPS level, only 5% is on AIF, and AIF is not all this. There are other REITs and everything obviously there. Apart from that, with the FDI policies in place, and it attracts to AIF. So we are not looking at that. So to counter that and make sure that it's complementary, we can bring in foreign investment. I think there's much more that needs to be done here. ARCs are very vocal on this, but I think on a policy level, I think there's much more that can be done here on an AIF level. Then you can have an enhanced regulatory overviews. You should anticipate stricter regulatory measures for greater transparency. There have been issues with how ARCs take over the capital and become resolution applicants in the past also. So there's no malfeasance or malified actions by ART, and ensure stakeholder protection and accountability while they act as IS. Apart from this, there's nothing to prevent the ARCs from taking standard assets also, and assets that have very recently gone bad. So they should incorporate more technology in how they operate, so that they can detect early and intervene in potential insolvency cases. And they should offer preemptive restructuring solutions which they are an expert at anyways. ESG considerations are something to be looked at from future perspective. The World Bank is also trying to bring in a new policy. So the World Bank business rankings report, the ease of doing business is now being replaced, and now the new scoring factor that is coming in place has ESG factors also there. So that will also be a consideration. Apart from this, the ARC should invest in training programs to enhance their professional capabilities. Another one point, this is a mixed thing, but NARCL could have a central role in consolidating and resolving large stressed assets. We don't know how, we don't have sufficient experience right now. Players like NARCL, as we have seen in China, there have been about 4 state NARCL-like entities, and what they've done is it might help to get better price discovery, but we need to see more experience in this regard, and be continuously vigilant so that we help entities like NARCL to perform well. Any questions?
Thank you, Mr. Asit, for such a vibrant presentation and highlighting the key challenges. Yes, questions, please.
Yeah, it can happen. It can happen, but that will not be a CRP situation, obviously. But these ARCs, they can lend their expertise role, and the board of management will be separated, and the VC funds would, what they'll do is they'll bring these ARCs in, and they'll run the company for some time, restructure it, and then pass it over to some. This can very possibly happen. Yeah.
I haven't seen ARCs coming at a very early stage.
Yeah, so far they have not.
I haven't seen that. So I don't know how many of you track Sanya, the advisor to the minister.
Sanjeev Sanya.
Right, Sanjeev Sanya. You should, it's easy to sit here and give a policy prescription. But what works on the ground is something that we have to appreciate. He's very recently written an article on mediation. As opposed to the conventional wisdom here or anywhere, most of you will say that mediation should be made compulsory. Are you with me? Most of you will say that, isn't that? Sanjeev Sanya, advisor to the Prime Minister, has said the other way. He said it should be voluntary. Because he's the guy who works on the ground and looks at data, looks at what works in the real life. We can sit here, think of anything. Yes, there can be many prescriptions, but we have to see what works on the ground. In my personal experience of insolvency resolutions in 7 years, I don't see mediation working at all. The creditors, oh my God, they treat debtors with such disregard, you cannot imagine. They won't sit across the table with themselves. And it's not a dispute, it's recovery. Mediation is where there is a dispute. Here, the creditor has a recovery against the debtor. Where is the dispute? What are we trying to fit here? It is being very often taught that we should have mediation in insolvency proceedings. I'm sure there is a role of mediation in certain settings of the insolvency processes. Yes, even NCLT has appointed court commissioners to allow mediation between parties where they don't want to consume the time of the court. And NCLT, as such, being a summary proceedings court, doesn't have the luxury of spending too much time. So very rightly, it is a prescription available on the table for you. But I don't think it is something that you can impose. It is something which can work on a selective basis. And still, mediation is something I haven't seen working on the ground anywhere. Arbitration maybe has taken off better than mediation. I think people are still averse to mediation. We'll have to really wait for it to work.
So, US regulations and taxation in insolvency to resolve the bankruptcy.
There are much more evolved bankruptcy regime. You please look at when was the US bankruptcy law enacted. We are just 7 years old, and we have to understand our own culture, society, the construct of our society, our people, our attitude, our way of looking at things, which is very different from US. In US, I think all of us know that Donald Trump went through many bankruptcies. He was also the president of US. It's a very defining thing in US. I don't think as a society, we have still come to the terms that, a bankrupt person is just a normal person. Is that, I don't think that is the case today. We are looking at fresh start, we are looking at bankruptcy, we are looking at bankruptcy registers. But I think the stigma with bankruptcy in India is not going to go away, like possibly in a developed country like US. Yeah.
I'm sorry to interrupt at this juncture. I will not take any more questions. Next session was supposed to start at 2. It's already 2:10. So we'll be starting next session at 3. That means sessions will end at 6:30. So we can't detain the participants even of online presentations till that time. So if there is any more discussion, we are proceeding to lunch in the guest house. We can discuss over there. I'm so sorry to cut short the session. I'm thankful to Ms. Namisha Singh and Ms. Archana Sharma, Mr. Asit Behera, and especially to Mr. Anil Katia for giving insightful thoughts on the working of the Insolvency and Bankruptcy Court. On behalf of Rajiv Gandhi, National University of Law, I'm grateful to the officers of IBBI and Mr. Anil Katia ji. I'm also thankful to all the participants. Now we need to proceed to lunch. I'm so sorry to have cut short. Thank you so much.